Welcome back to another deep dive. Today, we are heading to the borough of Queens, New York, to look at something that, quite honestly, happens every single day.
Right.
We are looking at a crack in the sidewalk, specifically the pavement in front of a building at 8920 55th Avenue.
It sounds incredibly mundane when you start there, a standard trip and fall.
Yeah.
I mean, it is the absolute bread and butter of this civil court system.
Exactly. A man is walking, he trips, he hurts his knee, he sues the building owner. If you look at the court docket in New York, there are thousands of these.
Yeah.
But
That's not why we're here.
You know us. We aren't here to talk about cement maintenance. We are here because when you peel back the layers of this specific case, Jason Aristizabal wrote us via the 89 Bonnie Realty Corporation, you find something that looks a lot less like a clumsy pedestrian.
A lot more like a scripted scene from a crime thriller.
That is the perfect way to frame it.
Because the documents we are analyzing today, I mean, we're talking legal filings stretching from 2022 all the way to February 2026, they suggest that this cracked sidewalk is just the stage for a much larger production.
Right.
We aren't just talking about a bruised knee. We're looking at allegations involving a mysterious runner, a witness who was scrubbed from the files, a deportation to Venezuela, and a federal RICO conspiracy.
And just for clarity, RICO stands for Racketeer Influenced and Corrupt Organizations. It's the heavy artillery statute they use to take down organized crime.
It is.
So the stakes here have shifted dramatically from who fixes the concrete to is this entire lawsuit a fraud?
Precisely. And our mission today is to sift through these sources, the summons, the medical reports, the firing motion papers, and figure out if this is a legitimate accident caught in a web of paranoia
or if it is, as the defense claims, a cog in a massive organized fraud machine.
Let's start with the narrative itself. We need to ground this in the official story.
Okay, so according to the plaintiff, Jason Aristizabal wrote us, what happened on June 21st, 2022?
It's 11:00 a.m. on a Tuesday. Jason is walking past that building on 55th Avenue in Queens. According to his bill of particulars, which is, the document where he details the accident, he encounters a defect, a broken, cracked, uneven section of the sidewalk. He trips and falls.
And we aren't talking about a minor scrape here. The injuries listed are significant.
Very significant. He claims he tore the meniscus in his right knee, suffered a high-grade tear of his ACL, and messed up his cervical spine.
And we have to be fair to the documentation here. This isn't just him saying, ouch.
No, not at all. He has surgical records.
Right. I saw that in the file. He underwent arthroscopic surgery on that right knee.
Correct. The file notes surgery at Triborough Ambulatory Surgery Center. He also lists spinal issues requiring an epidural steroid injection as recently as December 2024.
So nearly 3 years later, he is still getting needles in his spine.
That is the narrative. A life-altering injury caused by a negligent landlord.
And because of that, the financial demand is huge.
It adds up fast. He claims over $90,000 in physician services alone.
Wow.
Plus, he claims lost wages. He was working as a driver for a company called Enrique Construction Corporation. And he says this fall cost him about $22,000 in earnings.
So, on one side, we have a man with a surgically repaired knee asking for compensation, standard stuff.
Yeah.
But here's is where the thread starts to pull.
It really is.
When he filed this lawsuit in 2022, he was represented by a well-known personal injury firm called Subin Associates. But now, in 2026, he is represented by a different firm, Ronnie and Taub.
And that switch in representation, it might seem like boring administrative shuffling, but it is actually a critical pivot point in this story. Because right around the time the lawyers changed, the defense, the building owner, stopped acting like a normal landlord.
Right. Usually the defense says, the sidewalk is fine, or you should have watched where you're going.
Right. Comparative negligence. But they aren't relying on that here. They're on a manhunt. We are looking at filings where the defense is trying to subpoena third parties that have nothing to do with the building.
Who are they going after?
Specifically, they want records from T-Mobile and an accountant named Eugenia Aronoff.
Which begs the question, why does a building owner need the plaintiff's accountant? Are they auditing his taxes?
Well, they aren't looking for the plaintiff's finances per se. They're hunting for a connection to a non-party, a man named Jorge Lupi.
Okay, so let's bring him into the spotlight. Who is Jorge Lupi?
According to the affirmation of Daniel A. Johnston, and he is a lawyer for an insurance company involved in related cases. Jorge Lupi is what is known in the industry as a runner.
A runner, so not someone jogging in the park.
No. In the world of insurance fraud litigation, a runner is a recruiter. They are the middlemen who find people to file lawsuits.
I see.
The allegation in the sworn affidavits is that Lupi operated a network of companies with official-sounding names like Medico Legal and J&D Investigation Services.
Gives it a veneer of legitimacy.
Exactly. But the defense alleges his methods were anything but legitimate. They claim he used Instagram, his handle was apparently at jlupi123, to recruit people to stage accidents.
On Instagram.
Or exaggerate injuries. On Instagram.
And there was money involved, obviously.
Huge amounts. The filings allege he took carve-outs from litigation funding. Basically, when a plaintiff gets a loan against their future settlement to pay bills, Lupi allegedly takes a cut.
A consulting fee or something.
An origination fee. The defense believes Lupi orchestrated this sidewalk fall in Queens.
So the defense theory is, Lupi finds Jason, tells him where to fall, and then takes a cut of the money. If I'm the defense attorney, I want to depose Jorge Lupi immediately.
You want to put him under oath.
Absolutely.
And that is the problem. They can't. Because as of November 2025, Jorge Lupi is gone.
Gone as in hiding.
Gone as in deported. The FBI confirmed in an email, which is attached to the court filings as Exhibit D, that Lupi has been deported. He was sent back to Venezuela. And apparently, his lawyer says he is making arrangements to move to Spain.
Wow. So the alleged mastermind of this ring is in Venezuela or Spain, completely out of reach of a Queen's subpoena.
Which creates a massive evidentiary hole. The defense cannot ask Lupi, did you tell Jason to trip? So they are trying to fill that hole with digital surveillance.
And that's the T-Mobile records?
That is why they are demanding the T-Mobile records. They want the digital breadcrumbs.
They want to see if Jason's phone was texting or calling Lupi's phone around the time of the accident.
Exactly. If they can prove they were in communication, the random accident theory takes a massive hit.
But I want to play devil's advocate here for a second. We have to be careful. Just because there is a guy named Lupi who scams people, and just because Jason might have crossed paths with him, that doesn't prove this specific fall was faked.
No, it doesn't.
You can know a bad guy and still legitimately trip on a crack in the sidewalk.
That is the million-dollar question. What evidence is there in this specific case? The defense counsel, in their reply affirmation, lays out what they call objective inconsistencies. They claim Jason simply cannot keep his story straight.
I saw that in the notes. It's like a game of telephone, but with his own doctors.
Right. The defense points to the contemporaneous medical records, the notes taken by doctors right after the accident. They claim that initially the plaintiff said he tripped and fell on the street.
Okay.
Then he changed it to misstepped and accidentally fell while walking. And then later on, the story became that he tripped on a tree root.
Misstepped is a very specific word. To me, misstep sounds like I was clumsy, whereas tripped on a tree root sounds like the city owes me money.
Precisely. And in a fraud investigation, those shifting narratives are red flags. Why does the story evolve? But the defense goes even darker. They point to the ambulance report.
The pre-hospital report?
Yes. The report says he was found lying on the sidewalk complaining of knee pain. To most people, that proves he was hurt.
Yeah.
But the defense argues this is part of the staged location site protocol.
Staged location site, that sounds clinical.
The theory, based on the RICO complaint filed against the broader ring, is that the participants are directed to go to a specific spot that has a defect, like a cracked sidewalk laydown, and then call the ambulance.
So the ambulance report proves he was there, but it doesn't prove he fell.
That's the argument. It's incredibly cynical. But if you accept the premise of the fraud ring, the logic holds up.
The thing that really made me stop and reread the file, though, it wasn't the ambulance. It was the witness.
The missing witness.
Sixto Delgado. This part is wild.
It is.
So early in the case, when Jason was represented by that first law firm, Sabin Associates, they identified an eyewitness, a man named Sixto Delgado.
Correct. He was listed as someone with first-hand knowledge of the fall. A corroborating witness is gold in a trip and fall case.
But then Jason switches lawyers to Amrani and Taub, and suddenly in the new discovery documents, Sixto Delgado's name is erased.
He is just gone from the witness list.
Why hide your eyewitness? I mean, if I actually tripped and my buddy Sixto saw it, I'd want him testifying.
Unless Sixto Delgado is a liability.
Which he apparently is.
The defense found out why. It turns out Sixto Delgado has his own lawsuit.
Of course he does.
He sued a different building in Queens, 5005 43rd Avenue Core, for a trip and fall that happened in November 2021, just months before Jason's fall.
Let me guess. His injuries.
I'm looking at Sixto's bill of particulars right now. Lumbosacral spine, right knee, right shoulder.
It's the same list?
It is eerily similar. Broad-based central disc herniations, meniscal tears, and guess who represented Sixto Delgado initially?
Subin and Associates.
Subin Associates.
Okay, so let's connect the dots. You have two guys. They both have similar falls on Queens sidewalks a few months apart. They have almost identical injuries. They use the same law firm. And one was a witness for the other until he was scrubbed from the record.
And the defense connects them even further. They cite a court order from Sixto's Case Source 5 in our stack, where a judge actually ruled that the defense could add a fraud counterclaim against Sixto. The judge noted that the connection between the plaintiff and individuals in other actions was supported by more than just innuendo, and that Sixto, he may actually reside with Jason Aristotle Rodas.
Wait, they might be roommates.
That is the implication. So you have roommates, both tripping, both suing, both using the same doctors and lawyers. The defense argues this is the definition of a pattern.
It looks bad. I admit it looks suspicious, but we have to be fair here. We have to look at this from the plaintiff's perspective, because his new lawyer, Maria White, is fighting back hard.
She is, and she has a very strong legal argument. In her affirmation in opposition, she calls this whole thing a fishing expedition.
Which is a great legal term.
It basically means you are casting a net, hoping to catch something, without knowing if there are any fish there.
Oh.
She cites a landmark case, Capon v. Koch.
Okay, break that down for us. Why does that case matter?
Basically, under New York law, if you want to subpoena a non-party, like the accountant or T-Mobile, you need more than just a hunch. You need to show that the information is material and necessary.
You can't just violate someone's privacy because you have a suspicion.
Exactly. And Maria White is saying they haven't done that. She argues that the defense has zero admissible evidence connecting Jason Aristotle Rodas to Jorge Lupi.
So no text in the file, no photos, no checks.
Nothing. Her point is, you can't subpoena my client's private phone records just because you found fraud in other cases.
It's harassment.
Right. She calls it speculation and innuendo, and she points out that the defense is filing these exact same subpoenas in multiple unrelated cases. She lists cases like Gina Lombana v. Elmbeck Owners and Richard Lore Merchant v. NA67 LLC.
So she's saying they're just throwing everything at the wall to see what sticks.
To delay paying the claim. That's her argument.
And that's a fair point regarding privacy. I mean, if I legitimately flipped on a crack, I wouldn't want T-Mobile handing over 10 years of my text messages just because my original lawyer is being investigated.
And that is the tension here. The defense says, we can't prove the connection unless we get the phone records. The plaintiff says, you can't get the phone records until you prove the connection.
It's a catch-22.
It is.
We keep mentioning the law firm, Subin Associates. They seem to be the thread tying Jason, Sixto, and maybe even this Luthi guy together.
They are central to the defense's theory. There's an affidavit from that insurance lawyer, Daniel Johnston, that explicitly mentions a pending federal case. Union Mutual Fire Insurance Company v. Subin Associates, LLP.
A federal case. That escalates things.
Yes, in the Eastern District of New York.
Yeah.
And in that federal case, Jorge Lupi, our deported runner, is also a named defendant.
So the insurance company is suing the law firm and the runner together in federal court, alleging a massive scheme.
Correct. And that raises the stakes from a simple slip and fall in Queens to an allegation of systemic insurance fraud. And the defense in Jason's case is trying to drag that federal conspiracy down into this specific sidewalk case.
It's incredible how complicated this gets. You start with a trip on a sidewalk, and you end up with the FBI, federal lawsuits, and guys fleeing to Spain.
But we have to remember, and this is crucial, Jason Aristotle Rodas has had surgery.
Right. They cut into his knee.
He had a meniscectomy. He had injections in his spine. These are invasive procedures. If this is fraud, the commitment to the bit is terrifying.
You are letting someone operate on you to make a buck.
Or he really did fall, and he just happened to hire a lawyer who is sketchy, and he happens to have a roommate who also fell.
Coincidences do happen.
They do, and that is why the standard of proof for fraud is so high. The defense has to prove he didn't fall, or that he saged it. Inconsistencies in medical notes are common.
Sure, people are in pain. They misspoke.
A missing witness is suspicious, but maybe Sixto just didn't want to get involved.
So where does that leave us? The defense is asking the judge to let them dig into the litigation funding and the phone records.
The judge in the Sixto Delgado case already allowed the fraud counterclaim to proceed. But in this case, Jason's case, the battle is still raging over these subpoenas.
And they're arguing that because Lupi is gone.
They have no other way. Lupi is deported. We can't depose him, so you must give us the documents.
It feels like the clock is ticking, too.
It is. The filing notes that T-Mobile only keeps text message metadata logs of who texted whom for 2 years. The accident was in June 2022.
We are in February 2026.
So the data might already be gone.
Wow.
The defense is scrambling to get a court order for data that might have been overwritten a year ago.
That is a sobering thought. The truth might have been deleted from a server somewhere in a T-Mobile data center.
That's the reality of modern litigation.
Yeah.
It's a race against data retention policies. If they can't get that data, they are left with circumstantial evidence.
So what does this all mean for us, the people walking around on sidewalks?
It highlights a massive hidden economy. We walk past construction sites and cracked pavements every day. But beneath that concrete, there is a war going on between insurance companies and these alleged accident rings.
And cases like this, Aristides Rodas vs. 89 Bonnie Realty, are the battlegrounds.
They are. And the cost of this war, it's in our rent, our insurance premiums.
Absolutely. If fraud is as rampant as the RICO complaint suggests, billions of dollars are changing hands for accidents that might be scripted.
But if the defense goes too far, legitimate victims get harassed and their privacy invaded.
Yeah.
It is a very delicate balance for the court.
It really makes you look at a wet floor sign a little differently, doesn't it?
It certainly does.
Yep.
It makes you realize that every slip is a potential lawsuit, and every lawsuit is a potential conspiracy.
Before we wrap up, I just want to leave our listener with one thought to mull over. We know Jorge Lupi was deported. We know he's seemingly out of the game. But the runner system doesn't rely on one guy. If Lupi is in Spain sipping sangria, who took his place in Queens?
That is the question. And with the digital trail fading, will we ever really know what happened on June 21st, 2022 at 11:00 a.m.? Or will this just settle out of court, another line item in an insurance ledger?
A mystery buried under the sidewalk. Thanks for joining us on this deep dive. We'll catch you on the next one.